I would like to just give way to our panel, specifically by indicating that this panel has been a work of all panelists and ideas. The topic here is consultations, and initially we thought of calling it the principle of participation in investment projects and international arbitration. The whole idea was to start the conversation, which has already started because some of the panelists have already talked about this topic in workshops and in other fora. But the idea was to continue and even start a stronger conversation on the consultations that sometimes are demanded in certain jurisdictions with and by those people who are actually involved and could be affected by certain certain foreign investment projects or domestic projects. Recently we have had a number of decisions, exit awards and investor state awards that have touched upon that topic. And you see the issue rise whenever there's a mining concession or there's a hydroelectric project that may affect individuals or simply projects that may touch upon communities that live in the area or somehow would be affected by investment projects. So that is the topic at hand. And with us, we really have an incredible panel. And I couldn't stress more how incredible this panel is, because we're going to take you from a perspective of constitutional domestic law concerning one specific jurisdiction, Colombia, to then Inter-American human rights courts, and then up to public international law and the principle of participation somehow for specific communities, indigenous communities, but not only indigenous communities, and then get to the idea of consultations in investment arbitration. And that path that I have just laid out is in front of your screens, and in some of you in front of your faces, as we have with us Justice Natalia Angel, and Justice Angel Cabo has agreed to come to the floor and speak specifically and only about issues related to the participation principle under the Colombian Constitution. And I, as a moderator, have the task of making sure that she does not get any hypotheticals or any facts, because for obvious reasons that would or may affect her work, which we don't want, of course. Then we have Professor Andrea K. Jorklund, and Professor Jorklund is a full professor at the Yves Fautier Chair in International Arbitration and International Commercial Law at McGill University Faculty of Law. She, of course, is a frequent expert and arbitrator in investor-state arbitration disputes and court proceedings related to them. She's many more things. I don't want to embarrass anyone, but really the panel that we have here is an incredible one. James Anaya is an international recognized scholar and author in the areas of international human rights and issues concerning indigenous peoples. He served as the UN Special Rapporteur on the Rights of Indigenous Peoples from 2008 to 2014. And in addition to that, he is teaching, and he has teaching and scholarship. He has also litigated major cases involving human rights of indigenous peoples in domestic and international tribunals. He has also appeared and served as arbitrator at ICCID, and he has written a book which I read about 20 or 30 years ago, on the rights of indigenous, the international principles of indigenous peoples under international law. And I know that I misquoted him. But the interesting thing is that even 30 or 20 years ago, when I read the book, it had already, you know, a very broad research on the work of many constitutional courts, including the Colombian Constitutional Court, which has a principle of participation, and of course the basis of international law and treatment of customary international law in that book is really deep and clear. Then we have Professor René Urueña, who is a professor of public international law at the Universidad de los Andes. René has appeared before the Constitutional Court to talk about matters of expropriation, among other things. And he has a doctorate as well. And he's here with us to address the issues of the Inter-American Court of Human Rights and issues of consultations. Last but not least, we have Ana Milena Vives, who is an international paralegal at Extragy. And as you see, at Extragy and the World Arbitration Update seeks to have intragenerational panels where we have extremely recognized and solid attorneys and lawyers, but we like the conversation amongst peers and non-peers, and that is why Ana Milena is here. She will take it on to make a presentation on the status or the update of the social or the consultations and social license to operate first, and then to give a sense of what are the cases in investor-state arbitration that are relevant to the discussion. Ana Milena is also a student of economics and law at the Universidad de los Andes, and a lot of the technical work that you will see throughout the week is thanks to her, because she has been spending endless nights making sure this goes smoothly, including during the whole weekend, and I can attest to that. With that, I would like to welcome you, and let's start first with Ana Milena. Ana Milena, give us a sense of what has been happening in investor-state arbitration, and what is the notion of social license to operate.
Okay, thank you very much, Jose Antonio, for the introduction. It is truly a pleasure for me to be here today among these amazing panelists. So for the following minutes, I will try to give a very brief crash course on the concept of the social license to operate and the development of the concept within international investment arbitration. Now, to begin, let's answer the question of what exactly is the social license to operate. Now, please keep in mind that this is a fairly new concept, and it represents the acceptance of approval given by local communities or stakeholders towards an industrial project. Now, it is relevant today to discuss this topic because there is currently an increase in the legal regulations surrounding social actors and communities involved in or affected by such projects. Now, though, keep in mind that this concept being fairly new, and although very similar, is not the same as the right to community consultations. It is not generally recognized within domestic legislation. And for this reason, it is very difficult for it to be recognized as a requirement within an investment process. Now, we could say that there are four main characteristics of the social license to operate. The first one being that it cannot be obtained by simply requesting it from a governmental authority or by simply paying a fee for it. It requires far much more than money. And for this reason, there are no predefined parameters that a company must follow. And this goes in contrast to say with the legal license to operate, which a company can just follow a certain set of steps and obtain it. So this concept could be said to be very abstract and have not one instance that can apply to everybody. Now, the second characteristic being that it is intangible and informal. And what this means is that it is given by the affected community or by civil society at large. The third one being that it is constant and specific. Now, this means that the company must take into account the special characteristics characteristics and peculiarities of each communities in the process of obtaining the license. And even though we cannot say that there is a one-size-fits-all approach for this, and there definitely isn't, there are still several recommendations that are said to be followed for a company to obtain it. And an example of this could be, for example, the establishment of appropriate communication lines within the community and the company. Now, this is preferably done with the support of the local government. The fourth and last characteristic is that even though it is intangible and informal, it could still be said to be enforceable from the economic and legal perspective. And the reason for this relies that the upfront costs associated with gaining social acceptability are greatly reduced if the social license is in fact achieved. Now, to give a few examples and to have clarity with what this means, let's say from the economic enforcement perspective, this does not mean specifically that a government sanctions or imposes a penalty towards the company, but rather that civil society can achieve this. And the classic example for this is through consumer boycotts. And from the legal enforcement perspective is that there are appropriate regulatory measures such as the adoption of legislations that put at the center of the discussion the social license to operate. And a good example for this would be when a government prior to obtaining a legal license requires that a company obtains a social license. So it makes it a requirement of the legal license and as such included within its legislation. Now, with this in mind, if we say that it is intangible, it would say that it is given by a community and not by a government, then what exactly will be the consequences of not obtaining a social license to operate? And please keep in mind that there are no specific legal penalties imposed, and that in principle, because of course there could be certain exceptions, the social license to operate does not entail a breach of an investor's obligations under international investment law. Nevertheless, there are great consequences for a company for not obtaining the social license to operate. And this is mainly because there could be protests or blockade attempts made by the community because, as said before, there could be consumer boycotts, or let's say even if a company has obtained its permit years ago and it has done everything, let's say with the approval of the government, because of the previous examples of consumer boycotts and protests, there could be legal challenges imposed to it that could halt the development of the process, or that could even maybe impede that it is born. Now, shifting the focus towards international investment arbitration, these matters are usually not discussed within it. What happens is that sustainable development, responsible business practices, or reference to human rights are generally not part of the reasoning of international investment tribunals. And if we use bilateral investment treaties as an example, we can see that the text of them usually do not contain specific languages that reference corporate social responsibility or social development. And the reason for this lies behind the idea of a relationship between the investor and the government being asymmetrical in nature. So what this means is that while the BIT might impose obligations upon the state, it merely grants rights to the investor. So with this in mind, there has been very few cases that have shed a light on this topic. And given the time constraint, we can only discuss today 3 of this. The first one will be in Copermesa versus Ecuador. And though keep in mind that in these 2 first examples that I'm going to present, there is actually no specific mention of the social license to operate in the text, but nevertheless, it is considered to develop the concept to an indirect manner. So for example, in Copermesa, what happened was the tribunal analyzed and considered the concept throughout the prism of contributory negligence. And it found that in the end, it had, among other things, an impact in the quantum and causation of the case. So what happened in Copermesa was that the tribunal did take into account the contributions of the company towards the social conflict that occurred around the investment project, and found that its actions did contribute to it. And for that reason, it reduced the compensation and owed to the claimant by 30%. Now, a similar case will be in South American silver versus Bolivia. And once again, the tribunal did not use the concept of the social license textually, but it still assessed it through the actions that the company had done that contributed to the situation. Now, once again, as in Copermesa, the tribunal looked at the actions of claimant, looked at the effects that it had on the social conflict, and found in this case that because of Bolivia's actions in the process of expropriation of South American silver, and because there was no compensation in the end, that the amount of compensation owed to claimant was in the end, could not be reduced in the end. Now, the last, and to my opinion, the most interesting case is Berkeley Mining versus Peru. And I say that because this was the first investment arbitration case that actually gave an in-depth analysis of the concept. And in here, once again, as in the previous cases, the tribunal looked into the actions of claimant, looked at the consequences that his actions had on the social conflict that was surrounding the investment project, and concluded that it could have taken a greater effort in its consultation process and in its community outreach. Nevertheless, it determined that during the 3 years that the project was undergoing, the Peruvian government had apparently gave its authorization and approval of it, and never directly went against it or said or shown that it did not agree with the situation or how the community consultation process was undergoing. And for this, the tribunal considered that the actions of the Peruvian government constituted as an approval and that it showed reasonable expectations for claimant in the situation. Now, one very interesting thing about this case is the dissenting opinion of Judge Philip Sands. And now, once as the tribunal did, Sands considered that the claimant did contribute to the social unrest and that his actions could have been better, but differs from the tribunal in that it considers the ILO Convention 169 in its reasoning. And it said that though the ILO Convention does not impose directly obligations on private investors, it still should hold significant legal value within this context. And then he brings into question Article 15 of the ILO Convention. And what he argues is that, and these are sort of his textual words, is that it may be the function of the state to provide a stable legal framework that ensures that the consultation process occurs and that the actions are consistent with the ILO Convention. But nevertheless, it is not the state functions to hold the investor hands and deliver a social license out of this process. And for this reason, he argued that the FTA and any or the sort of bilateral investment treaty should not be used as an insurance policy for the investors in the cases that it fails to adequately undergo a community consultation process. And this gives us a great and interesting contrast between the two decisions, because in the end, what the tribunal says is that it is the obligation of the state to monitor closely the efforts conducted by the investor and for to obtain consent from the indigenous communities, and that the state must voice its concerns throughout the whole process. And for this reason, because Peru had not voiced its concerns during the process of 3 years, it concluded that the damages could not be reduced and laid the responsibility mainly on the Peruvian government. Now, in contrast, what Sands argue is that obtaining the social license to operate is the responsibility of the investor, and that a failure to secure the license should have been taken into account by the tribunal once calculating the damages and the compensation to be awarded. Now, with this in mind, this concept is very interesting, and hopefully we could have a great discussion in what remains of the panel, since it presents itself, the social license to operate presents itself as an opportunity to insert binding obligations upon investors and governments that ensure that community rights are not only heard, but also respected throughout the whole process.
Thank you very much, Ana Milena. And with that in mind, with a greater sort of sense of clarity as to what a social license to operate means, and hopefully also a greater sense of clarity as to the recent cases. There are more cases, and some of them will be addressed by some of our panelists. I would like to invite Justice Natalia Angel to take the floor and specifically address the question of from the perspective of Colombian constitutional law and the issue of the principle of participation, specifically with regard to the right, if any, of consultations of and to communities. So Justice Natalia Angel Cabo, please take the floor.
Thank you, Jose, and thank you for the organizing of this panel. Is amazing. I wish I could speak English as Emilian. I don't speak that fluently, but I will do my best in my 7 minutes that I have here. So I've been asked to talk about participation, but as I said to Jose, participation is a very broad concept in the Constitution, and there are several manifestations of participation. So I'm going to concentrate in two, which is the constitutional jurisprudence on indigenous consultations, and if I have time, on something that was kind of on the discussion in 2017, 2018, that was popular consultations concerning mining projects in Colombia. So this would be the focus of my presentations, those two topics. But I imagine that not everybody is familiar with how cases reach the Constitutional Court. So very briefly, there are two types of actions or public actions. One is public action of unconstitutionality. That means that any citizen in Colombia can challenge a law on constitutional grounds. So that's one of the reasons why we have a lot of cases challenging laws on constitutional grounds. And the other is the tutela action. And most of the cases of indigenous consultations and consultations in general come within the tutela action, that is a writ seeking immediate protection of a fundamental right that any citizen may bring before a judge. So we have very broad and easy way to approach the courts in Colombia. And so basically we had a very, very large jurisprudence on the right to prior and informed consultation of ethnic and tribal communities in Colombia. Jim Anaya, as Juan said, documented at least the initial decisions of the Colombian court. And this is basically because our constitution recognized that Colombia is a multi-ethnic and multicultural state made up of considerable number of ethnically differentiated communities. And the Constitution regards these communities as subjects of special constitutional protection. So they are the beneficiaries of series of affirmative actions with the objective of achieving material equality. There's also numerous clauses in the Constitution that makes up for that protection. We have as what we call constitutional block, which is a part of the Constitution, of course, the Convention 169 of the International Labor Organization. And we have several clauses in the Constitution that talks about participation. So our first article says Colombia is a social state, democratic, participatory, and pluralistic. Article 2 basically says that it is mandatory for the state to facilitate participation by everyone. Article 7 recognizes and protects the ethnic and cultural diversity of the Colombian nation. Article 40, and I'm just only reading some, it says that any citizen has the right to participate in the formation, exercise, and control of political power. And Article 330 says that indigenous territories shall be governed by councils formed and regulated according to the uses and customs of their communities. And these are only some of the articles that talk about participation in the Colombian Constitution, because it was kind of a core principle of the Constitutional Convention. So it is not surprising that if we have such very easy access to courts, and we have articles in the Constitution that expressly talk about participation and consultation, that the Constitutional Court in these 30 years of its work has basically has a very, very large jurisprudence. I'm using this data from basically study that Professor Urueña will publish very soon. So this, I didn't do the data, he shared it with me, but we have 70 from 1992 until 2021. So we are not including the cases of this year. We have 77 cases of unconstitutional public action and 143 tutela cases addressing specifically consultation, the right to prior consultation and informed consultation for indigenous communities. And it's interesting in this data that when cases of unconstitutional, when people challenge a law for unconstitutional grounds, there are some cases in which the court has declared the law unconstitutional. That is, in the 12% of those cases, the court declared the law unconstitutional, and in 9% partially unconstitutional. Still a large number if you challenge a law and by saying that basically the legislator didn't, the executive didn't do a prior consultation before enacting a law is kind of a large number. But definitely what is very large is the tutela actions, because in 76% of the cases, the court determined that there had been a violation of the right to prior consultation and ordered the protection. That means that most of the tutela cases that the court revised concerning the right to prior and informed consultation, the court will basically decide in favor of communities. And so that is a message to do the prior consultation, because it's almost for sure that if you don't, you will lose at the court. Some examples I'm just bring, because I only have 7 minutes. This is one example of unconstitutional public action, and I'm bringing this up because it was one of the first decisions in which the court declared unconstitutional a law enacted by Congress, and what it was the law 1021 of 2006, which was the general forest law. And so I'm just quoting what the court says. It is not less true that a project of the size, complexity, and implications of the one that intends to regulate forestry matters in an integral manner require that, as a condition prior to its approval in Congress, the government carry out a specific exercise of consultation with indigenous and tribal communities. And the court mandates this in several decisions. So, for example, when the Congress is ratifying an international treaty, if it affects communities, there's a mandatory that prior consultation takes place beforehand. So when we see, and this is again data from the Rennes study, there's examples of unconstitutional decisions in several ways, but in tutela action, it's interesting the cases that the court concedes. In 30, there are macro cases and micro cases, but I'm just quoting the data from the macro cases. In 33% of the cases concern infrastructure projects, meaning roads, dams, ports. And again, most of these cases, the court decides in favor of communities. 28% concern extractive industries, such as mining, oil exploitation. And 12% are other type of cases, for example, ethno-education and others. But that means that at least in the infrastructure projects and extractive industries, well, most of these cases, most of these tutela cases, and most of the time, they are decided in favor of the communities. So I'm just citing here some relevant decisions, because as I mentioned, there are more than 143 cases of tutela actions. But the SU, the name SU means that the court these decisions are decided by the 9 justices and they try to unify the rules of tutela action. So these that I'm mentioning here, the ones that said SU, are pretty relevant if you want to have an idea of how the court decides. And so I'm just going to bring very quickly some of the actual standards for prior consultations in Colombia. So first of all, for the court, prior consultation is a fundamental right. Second, it is mandatory in the event that an administrative or legislative measures has the potential to directly impact ethnic communities. So this idea of directly impact ethnic communities is very important, and to decide what impacts directly a community is a matter, it has to air the voice of the communities as well. It's not that, for example, a company says that might direct or might not directly impact ethnic communities, but it has to have the input of the communities. Another rule is that adverse or confrontational positions are not allowed during the prior consultation processes. It is a dialogue between equals in the midst of differences. Procedures that do not meet the essential requirements of prior consultations processes are not admitted. That is, assimilating prior consultations to mere administrative procedures, information, meetings, or related actions. It is necessary to establish effective communication relationship based on the principle of good faith. It is mandatory to define the procedures to be followed in each prior consultation process, in particular through a pre-consultation and or post-consultation process to be carried out in common agreement with the affected community. And this is very important. Before the prior consultation occurs, there has to be a pre-consultation that we basically agree on how the consultation will take place. To more, a single term should not be set to materialize the consultation process and search for consent. And this issue of timing is very contested. And so for many development companies said the timing is different, and the timing is different among communities. But the court has been very clear in saying that there should not be a set timing or a set standard, but rather you have to take into account the community, the process, etc. And it is mandatory to guarantee that the benefits of the execution of the work or this exploitation of the resources are shared equitably, as well as compliance with mitigation and compensation measures for the damage caused. Again, if you want, there are more, I just quoted some of the standards are very complex, but for example, SU 123, 2018, I think is it gives you a very broad picture of the standards that the court has. So this is with respect to indigenous consultation, but the court has also addressed other types of consultations that, as I mentioned, were in discussion, especially in 2018. So basically, the Constitution recognized a mechanism that is called popular consultation. That is a mechanism for citizen participation. It's not about indigenous consultation, it's for any citizen participation. That allows mayors and governors to consult local communities about issues of the municipality or the province. But from 2013 until 2018, several municipalities promoted popular consultations regarding mining projects. And there were almost 11 from 2013 and 2018. I have them all, but I don't have time to show it to you. But I just quoted once. The question that was asked was basically, do you agree, yes or no? And this is an example that mining and oil exploration and exploitation activities be carried out in the jurisdictions of the municipality. In this example was of Jesus Maria Santander, but there were many others. Not surprisingly, population said, no, we don't want the mining project to be carried out. So that really relates to your social participation concept. But the court of the Constitutional Court was confronted with the issue if those consultations were mandatory. And if the government should, for example, if the community, if the municipality said no to a mining project, if it was mandatory to stop the project, because the concept of consultation says that it's mandatory to basically accept what the people says. And so there's one decision where the court says, no, it will not be mandatory. And basically the court what discussed was the issue of the autonomy of municipalities vis-a-vis the decision of the national government. So in Colombia, we are a central state, not a federal state. And so the court basically addressed those tensions between the nation and the municipalities. And with this, I will finish saying that popular consultation is not the ideal mechanism to apply the principle for concurrence coordination between the nation and the territory within the framework of the postulates of the unitary state and territorial autonomy, since as a mechanism of citizen participation, it cannot be used to define whether in a territory activities of exploration, of exploitation of the subsoil or natural resources are carried out or not. The competence in this matter does not lie absolutely in the head of the municipalities and therefore exceeds their faculties. I must stress that I've read a lot of academic articles criticizing this decision. So I will say that this is not a close matter, but still contested. And I think it really relates to this idea of social consultation, as you mentioned, because even if the court said that this does not have a hold, that this kind of consultation was a way of people voicing or airing their voice opposing to projects. So that's something that must not be disregarded. And so with this, I will finish. Thank you.
Thank you. Thank you very much, Justice Angel Cabo. I think that we were sort of going through, initially the social license to operate, now into the principle of participation, specifically in consultation matters, specifically in Colombia. And what I note from both of the remarkable presentations is that there is a sense of evolution that we will see in this specific topic. I mean, you mentioned that there's quite a bit of criticism concerning the last ruling that you read, and that is not unusual. That may also be the case in investor arbitration. We already have an important case, the Bear Creek matter, which in itself has a criticism by one of the arbitrators. So evolution is part of investor arbitration, constitutional law, and public international law. And with that, I would like to ask Professor Urdueña, and thank you for the research that we are getting fresh out of the oven, or even in the oven, perhaps. I would like to ask you, how is the notion of consultations understood within the inter-American human rights context, and even context of some other nations in the world, and specifically in Latin America, if you have any of that?
Thanks, Jose Antonio. So I'm going to share my screen. All right, is that okay? Wonderful. So thanks, Jose Antonio. Thank you very much, and thanks for the invitation. So this research, the underlying data was gathered by Juan Camilo Herrera. So to make the reference there to the work that has been done, and also by the team. So thank you very much. I'm very proud and very happy to be in this panel, and well, particularly to share this panel with you, Natalia, after so many panels, and this is the first panel we'll be sharing after you became Justice of the Constitutional Court.
We were colleagues.
Exactly. So we want to take a second, to tell you how proud we feel of you becoming the Justice of the Constitutional Court and being part of our community. So congratulations. So, so what I want to do is I want to tell you in a couple of minutes how domestic constitutional courts and the Inter-American system interact with the international investment regime, particularly around the concept of prior consultation. So that's the idea. And this is part of a wider project that we're developing with the Max Planck Institute on International Law that looks at the interaction between transformative constitutionalism and international economic law. So I see some of the authors in that project, Guillermo here and some others who are online, who have been working on this as well. So how does transformative constitutionalism in Latin America interact with international economic law? We have a case, we have studies on monetary policy, tax policy, labor law. And here I'm going to talk about investment law. So, but this is part of a wider project. So basically, what is it that I want to discuss here? So the idea here is, as you can see there, excellent. So what's the challenge here? The challenge here is essentially that ultimately what we have is that, so there's a lack of indigenous voices and representation in investment state dispute settlement. So there is that problem. And why? Because investment settlement actually simplifies these very complex disputes and make them basically a conflict between an investor and a state, whereas, as we know, investment is a multi-actor issue that involves, in this case, indigenous communities. So there is that problem, and we frame it or understand it as a problem of voice and representation. And then, so the intervention here is that by integrating domestic constitutional review on the basis of the free, prior, and informed consultation standard, I'm going to use that acronym there, FPIC, for consultation standard. So by combining domestic review with the consultation standard, then that becomes a platform to add complexity to the ways in which investment arbitration and domestic courts, domestic constitutional courts, can deal with this lack of voice. And by doing so, that injects both resiliency to the investment regime and also ultimately legitimacy to the investment regime, because it is open to new voices. That ultimately is a way to resist the huge backlash that we're seeing against the investment regime. And how would this work? So basically what I'm going to do in the next couple of minutes basically is I'm going to look at the consultation standard on consent, so not only consultation, but also consent in the context of Latin America first, and then I'm going to see how that consultation and consent standard might be injected into investment arbitration through domestic constitutional review of international investment law. That's more or less the idea. So first to begin, so about the standard. So basically, I mean, this is something that is not marginal. As we know, 8% of the population in Latin America self-identifies as indigenous. So we're talking about 45 million and even more, depending on how you count them. And importantly, so if we look at this from a Latin American perspective, 15 of the 22 states that are parties to the ILO Convention, to the ILO 169 Convention, are Latin American. So this is really, when we talk about ILO, we're really talking about the Latin American treaty ultimately. Most of them are Latin American. And all states in the region have approved the 2017 UN declarations of the rights of indigenous populations. And even Colombia, that at the moment when it was voted, abstained, then a couple of years later, they accepted. So Colombia accepted. And this is important, as Justice Angel was referring to before, the 169 Convention has constitutional standard and in most constitutional systems in Latin America, except Chile. And we know that that discussion is, of course, occurring right now as we talk, and Brazil, where it is part of the domestic law of the land, but it has a infra-constitutional status. But this being said, it's really part of the public common law of the region. So this is something that is not marginal and touches upon a wide segment of the population. So if that is true, then also in turn, most constitutions, so it is not only that international law is part of the domestic system as the standard, but also domestic constitutions include some of them explicit references to the consultation consent standard. Bolivia and Ecuador include explicit references in their constitution. Colombia, Brazil, Peru, Guatemala, Ecuador, they don't, I'm sorry, Ecuador, that's wrong. Ecuador includes express reference. You should, there's a typo there. Colombia, Brazil, Peru, Guatemala, they don't include explicit reference, but as we saw, as Judge Angel was referring to, they have the right under their domestic system through case law. And then finally, where we don't find that right is in Chile and Costa Rica. So again, this is to convey the message that this is not marginal part of the basic common law of the region. And in turn, the idea of prior consultation consent has been developed by the Inter-American system. And this, of course, comes as no surprise, particularly after 2007, 2008 with the Salamanca case, which was confirmed in 2012 with the Sarayaku case against Ecuador. And basically, what's the standard there? If you have impact, you need consultation. If you have large-scale projects with higher impact, you need consent. And that idea was confirmed 2012 in Sarayaku, where the court, this is the Inter-American Court of Human Rights, explicitly says, look, nowadays, this is the common law of Latin America. It is the obligations of the state, and this is verbatim from the case, to carry out special and differentiated consultation processes where certain interests of indigenous populations are affected, and it's an obligation that has been clearly recognized. So, both bottom-up, top-down, we have a very specific obligation there. And that very specific obligation, then, what we have here is, because it is developed by the Inter-American system, that means that domestic judges in Latin America have to apply that standard as it has been developed after 2012, as part of what the Inter-American Court of Human Rights call the doctrine of conventionality control, meaning that not applying that standard entails international legal responsibility under the Inter-American system. And the standard, of course, has to be applied, the Inter-American standard in turn has to be applied by domestic judges when their constitution has a doctrine of blocus of constitutionality. So that means that when judges are thinking, so are deciding about these projects, they are engaging both international responsibility of the state and their own domestic obligations under domestic law. So if that is the case, then, so how does this play out in the context of investment arbitration? So we have that duty, we have the right and duty, of course, of consultation consent first, and that duty is both international and domestic. How does this play out in the context of investment arbitration? So that's the first pillar. What's the second pillar? Domestic constitutional courts in Latin America are increasingly engaging with international investment law as domestic courts. How? In 4 moments in particular, which you can see in the screen here. So the first one is they are increasingly reviewing BITs, so bilateral investment treaties, the constitutionality of BITs. Second, there are increased issues of concurrent jurisdiction between constitutional courts and investment arbitration. Third, of course, as we know, there is the possibility of domestic review of arbitral awards that are non-exit. And then finally, in domestic constitutional courts have to review state or private action to comply with investment awards. So the point here, the message here is in each of these 4 moments of interaction between domestic constitutional courts and investment arbitration, domestic constitutional courts have to apply the consultation consent standard as defined by the Inter-American Court of Human Rights. If not, they engage both international legal responsibility and domestic legal consequences. Most of the action up to now has occurred in Latin America in the first 2 moments. But there's nothing to tell us that the action is not going to move forward to domestic review of arbitral awards and finally to the review of action to implement the award. In the first part, in the first moment, so constitutional review of BITs. So we have several examples in Costa Rica. This is a common occurrence. The Ecuadorian Constitutional Court declared 16 BITs unconstitutional from 2010 to 2014 because it had to review whether Ecuador's BITs were in conformity with the new Ecuadorian Constitution of 2008. And the court said, no, they are unconstitutional because the 2008 Ecuadorian Constitution has an article 322, if I'm not mistaken, that basically prohibits ISDS. And then, of course, the court declared that they couldn't go forward. And then, as we know, the Colombian Constitutional Court has a long line of case law reviewing BITs. And the most recent one was 2019, decision C-252 of 2019, where, as some of you may know, the court adopted very wide-ranging interpretations that control or limit the ability of the Colombian government to ratify BITs. This decision was, of course, controversial, as some of you may have heard. I'm not going to focus on that decision that much, but this is to underscore that this is really a site of contestation about investment arbitration, domestic constitutional review. So when that happens, so the first moment is, all right, so how does consultation consent, how does the consultation on consent standard look like in this review of BITs? Well, three things. So the first one is the court might decide that the law that approves the BIT must be consulted. So that if there's no consultation, that then the treaty itself is unconstitutional. Second, that the BIT must mention consultation in its substantive provisions. If not, then the treaty itself is unconstitutional. And third, the court might say that the BIT must include special rules of indigenous participation in arbitral proceedings. Otherwise, it would undermine the right of prior consultation in that context. So these are three possibilities that we've seen both the Colombian Constitutional Court and the Ecuadorian Constitutional Court suggest in a way. The second moment, and I'm going through this very fast to keep ahead of time, but I mean, obviously, I'm happy to answer any questions regarding this. The second moment then, remember, what is the second moment? Concurrent jurisdiction. How would this look like in terms of concurrent jurisdiction? Again, concurrent jurisdiction is domestic constitutional courts exercise jurisdiction over the same conflict as an international investment, international investment arbitration panel. So two moments there. The first one is, well, the domestic court's decision on consultation can be read as a denial of justice, and therefore it can trigger international responsibility. So when the court decides that a certain project had to be consulted, and that because it's a domestic court, and therefore it cannot go ahead because it wasn't consulted, then the investor might say, among other arguments, obviously fair and equitable treatment, so on and so forth, that in particular, it could say, through this decision, the court is engaging in denial of justice and therefore engaging in the international responsibility of the host state because of the decision of the constitutional court or domestic court regarding consultation. And second, and this is something that we are starting to see more, the inter-American decision that a given project in the region should have been consulted or subject to consent is in conflict with a given project that is in turn protected by an investment treaty in the region. So that's the other challenge there. Let me go fast then to the third moment. Remember, the third moment is the review of domestic awards, and this is blocked, but the review of domestic awards of international investment awards by domestic courts. This, of course, happens with non-ICCID awards, and this occurs in the context of the New York Convention, so that we're clear. But in the context of New York Convention, in non-ICCID awards, UNCITRAL or any other rules, domestic courts may say that lack of consultation and consent is a violation of public policy, which is, as you know, grounds either to set aside not exceed awards or the possibility of refusal to enforce. And this is because remember that if we're talking about refusal to enforce under New York, we're not just talking about the fora of the arbitration, but also efforts to basically seek compensation in other states that are not necessarily the state where the arbitration took place. And then finally, and I'm going to finish up with this. Then finally, consent in review of our implementation, that obviously courts, particularly domestic constitutional courts, they have to review both laws and regulations that have to be adopted domestically to implement a given award, investment award, or domestic public or private action that has to be implemented to implement a particular or to comply with a particular award. And that in turn has to be subject to the standard of prior consultation. And then you have also this possibility of conflict. So in conclusion,
I think, yeah, I think it's great that we have the conclusions on the screen. I think due to issues of time, and I apologize for this, we're going to move to Professor Jorklund sorry, apologies to Professor Anaya, asking him how asking him specifically under public international law, the question of the prior consultations plays out, and whether it is or not a rule that must be upheld under public international law, both under treaty law and or customary international law. We're really eager to hear your perspective on this.
Thank you, Jose, and thanks for the opportunity to participate in this panel. And Renee has covered a good bit of the basics of public international law with regard to the duty of states to consult with indigenous peoples in particular. Of course, ILO Convention 169, which has been ratified by the vast majority of Latin American countries. Unfortunately, North America is lagging behind in that regard. But the ILO Convention 169 is not the only international treaty that's relevant, as implied by Renee. Also, the American instruments, as adjudicated by the Inter-American Court of Human Rights, in particular the American Convention on Human Rights and the American Declaration on Rights and Duties of Man, have been interpreted as grounding a duty of states to consult with indigenous peoples. And of course, there's the UN Declaration on the Rights of Indigenous Peoples of 2007, while not a treaty, represents a standard that the vast majority of states of the world have agreed to work towards, at least. And many have argued, as have I, that essential parts of the UN Declaration are parts of customary international or general international law, in particular the provisions on consultation. And I'm not alone in that opinion. Maybe I was 20 years ago, but now we have entities like the International Law Association, Committee on the Rights of Indigenous Peoples, and the association itself affirming that proposition. I want to focus on some particular aspects of the duty of consultation that distinguishes it from this general notion of a license, a social license, or from the general right to participation. There is a general right of everybody to participate in public affairs or in governmental matters, and that is, that right is affirmed prominently, most prominently perhaps in the International Covenant on Civil and Political Rights, which is widely ratified, including by all Latin American countries, and also to Article 23 of the American Convention on Human Rights. And that is a right that everybody has to participate in public affairs or matters of governance that that affect them. And that right is related to democratic governance and good social governance. The idea of social license, as Ana Milena indicated, is not well sourced in public international law. One can see it as connected with certain policy prescriptions that we find in international documents, perhaps most notably the UN guiding principles on business human rights, although the guiding principles speak specifically of the responsibility of business enterprises to respect human rights, and not so much in terms of social license. It's a very rights-focused document, and to distinguish the duty of consultation. First of all, it's important to understand that the character of this duty, and that character is that it is a safeguard. It's not so much a freestanding right among the catalog of human rights, but it has been expressed in the documents I mentioned, ILO Convention 169, the UN Declaration, and in the jurisprudence of the Inter-American Court as a safeguard for specific rights that indigenous peoples are understood to have, including their rights over lands, resources, their rights to sacred places, their cultural rights more broadly. The duty of consultation is triggered when there is going to be a government decision that might affect these rights. And that is how the UN Declaration on the Rights of Indigenous Peoples frames this duty in Article 19 and various articles in connection with specific rights, such as rights on lands and natural resources. That is how ILO Convention 169 frames the duty. It speaks of government decisions that might affect indigenous peoples and their rights. Article 15 speaks specifically to the natural resources, the interests and rights and natural resources that indigenous peoples have. When those might be affected, the government has the duty to consult. And so often we speak of it, and notably, the Colombian Constitutional Court, and now even the Inter-American Court of Human Rights have articulated a right to consultation. And yes, we can speak of it that way because it implies a certain set of entitlements on the part of indigenous peoples, but it arises initially both in the jurisprudence of the court and in these texts, these foundational texts, ILO 169 and the Declaration, as a duty of states, as a safeguard for specific rights that indigenous peoples have that others don't necessarily have, like such as rights in the lands and resources that are going to be affected by an investment project. Those are not rights that pertain to the general population. Those are rights that are specific to indigenous peoples, and hence a specific duty of consultation arises. And another feature of the duty, and alluded to by Renee, is the objective of those consultations. And the objective is to achieve, as in the words of ILO Convention 169, agreement or consent. The UN Declaration also speaks of the duty to consult in order to obtain consent. And the Inter-American Court, as Renee has indicated, has emphasized that consent is required when there is going to be a substantial impact on the indigenous peoples. And I would emphasize a substantial impact on their rights. And there's a logic here. If indigenous peoples or any other people's rights are going to be compromised, are going to be somehow materially affected, well, of course, it's natural that there needs to be an agreement to that effect. That would be the same with a private landowner, with a private counterpart in a business venture. If that counterpart's rights, if their rights are going to be affected, there needs to be some kind of agreement. And so that's the logic behind the consent. Again, going back to the safeguard characteristic. If there's going to be an affectation substantially, if a company is going to go in, if the government is going to allow a company to go in and materially affect the enjoyment of specific rights of indigenous peoples over the lands and resources, there needs to be some kind of agreement. And let me emphasize that it's not a simple yes or no, as many authorities and tribunals have indicated. There needs to be safeguards included in any consent, and the Inter-American Court has specified that there needs to be mitigation measures and all benefit sharing and so forth. So I could say a lot more, but I want to be conscious of time, and I want to hear from Andrea. But let me just end there on emphasizing these fundamental characteristics of of the duty of consultation, which is that it is a safeguard for the specific rights of indigenous peoples. It's distinguished itself from the general right of participation or social license in that way, and that a particular feature is the need to obtain consent when the material interests of indigenous peoples might be affected.
Thank you very much, Professor Anaya. And I think that you have sort of like summarized very specifically what may be the standards under public international law. Specifically, there, I would like to leave you with a question for after Professor Bjorklund's shares, whether or no, I think that you have answered, but just to have some clarity whether the actual result of the consultation is binding under international law for the state. I mean, which is a key question. I will leave you to think about it a little bit. And now I have the pleasure to introduce Andrea, who has been patiently waiting, and she will walk us through some of the issues in relationship to investor-state arbitration.
Thank you very much, Jose Antonio, and thank you and Ian for the invitation to be here with you today. So it's a challenge always to be last on a great panel. But I'm going to try to broaden things out a little bit from what Jim talked about in terms of talking about a social license, which, as Ana Milena explained, seems to be trying to encapsulate a relatively broad notion about whether or not there's community support for a project. It seems to extend beyond consultations and formal processes to encompass, broader support within a community. In a way, it's attempting to formalize an amorphous concept and assigning a legal term, license, to it also seems to be an attempt to formalize the idea. But I'm going to ask 3 questions or talk about 3 different topics. Some of them are questions to which I confess I don't really have answers. But just to say that I think there are some questions and difficulties in implementation, because I think generally the idea of a social license to operate seems, I'm going to say, appealing. It seems as if something that one wants. It seems like a good thing. But in fact, I think there are sometimes difficulties in implementation that are not always so clear. The first question is, who comprises the community? The second is related to the time period when support must be achieved. And then the third issue I'll address is some of the just a few observations about intersections with investment law and arbitration. But first, who comprises the community? I think in Ana Milena's introduction, she talked about the local community and other stakeholders. And of course, that really is the question: who is the local community and who are those other stakeholders? In one sense, especially if you're talking about an environmentally impactful project, you think you're talking about those who live in the vicinity of the project. But what if they are split? What if they don't agree about the project? What effect does that have on the social license? And we have there are certainly examples of this. There's a proposed liquefied natural gas pipeline in Western Canada that would go across tribal lands that are either owned or controlled by, or very important to, the Wet'suwet'en band of native peoples. But in that particular case, the band councils support the project, whereas other representatives of more traditional legal indigenous governance structures are opposed. So how do you reconcile a split within the community? Second question maybe is it the country, if you will, as a whole, or is it significant vocal interest groups? And there I can, as an example, I think you mentioned, Jose Antonio, Gabriel Resources versus Romania. We don't have a decision in that case yet, but the pleadings are available on ITA law. But there you have a situation where it seems that in large respects, the local community, this is about a gold mine, the local community would like to have the gold mine. The local community wants to have the economic development and the economic benefits that would ensue, but environmental activists who are not local, but who are Romanian, are very much opposed to the gold mine. So you might say, how do you reconcile that split in community? And certainly if we're thinking about environmental impacts, you know, the community might be much broader than just that those who live nearby, even if they're bearing the brunt of any damage. We know, as you know, Hurricane Fiona just swept through Eastern Canada, that global climate change, global warming has an effect on all of us. But you know, similar issues arise in different places. So in in Congo, in the Democratic Republic of Congo, you have questions about tree cutting, where under pressure from the international community, the government has not issued new timber cutting licenses for 20 years, but there is clearly unlawful cutting going on, often by foreign companies. There's community support to mobilize against that action, but what the community wants to do is to cut the trees themselves and get the benefit themselves. So that's anyway, these are just complex matters, but I guess I just want to raise the question about who is the community, how do we assess what the community is, and who has the, if you will, the authority to issue the social license or to withhold the social license if that's what's being discussed. Second question I wanted to discuss is the time at which support must be achieved. It's simplest, I suppose, to talk about at the time of licensing, right? Before a license is, let's say, some kind of license or formal license, some kind of concession permit is given. I think that's usually where we think the consultations come in, and that those then inform the government processes. You know, if that social, you know, does that, do consultations, we think the social license is broader than just consultations, but if consultations have been held and have proved largely positive, is that sufficient? Is the social license broader? How do we know when it comes? If there is formal approval of a project, but then the company loses the social license, right? As if you've got a long period of time in terms of operating a gold mine or operating another natural resource extraction project, then what is the company's obligation to maintain the social license? If the company does everything the company promised, yet the social license is still withdrawn, does that matter? Should that matter? How does that matter? And you know, so that leads me into my third discussion point, which is the kind of the real intersection with investment law. You know, if the project was lawful, and this I think is where we see this kind of tension in the cases that we've had to date, if the investment was lawful in terms of formal structures, where does this social license fall within that structure? It seems that before any approval is granted, then the lack of consultations, the lack of a social license should be grounds for not approving the project. Although even there we have some tension. And here I think about the Bilcon versus Canada case, in which one of the grounds for the environmental review panel's refusal to grant a license was that it was not consistent with community core values, which the investment tribunal, over the dissent of Don McRae, said was not really part of the governing law. But I think that was another example of this notion of a social license, of whether the community was buying into the project or not. Yet with investment law looking perhaps too formalistically, but looking formalistically at whether the formal procedures were abided by in the country's laws, then it seems that the social license to operate has limited ability to make an impact. It could be, it's not a formal obligation on the investor, but perhaps the failure of an investor to maintain a social license, particularly if there are requirements that seem more evident than others, might be grounds to excuse a fair and equitable treatment violation. Yet we see that reluctance in Bear Creek Mining versus Peru. You can see where it fits in the grounds of legitimate expectations. Does the investor legitimately expect it must maintain a social license? Here again, the amorphousness of the concept is a little bit hard to fit. In other words, it could go either way. Could argue that even as long ago as Metalclad versus Mexico, one of Metalclad's problems was that it did not develop a social license, even though that case was, I think, before that vocabulary had been developed, or at least I've never heard of it spoken of at that time. But overall, and this is my last observation, it seems to me that a lot of what we've talked about is that the social license idea really highlights potential governance deficits in the host state. Is there formal approval of a project notwithstanding significant community opposition? Is there formal approval of a project notwithstanding the inability of certain communities, and indigenous communities in particular, to really have a meaningful voice in the government? And we see this, I thought, in Justice Cabo's discussion, that the concern about lack of indigenous voices and representation is true in domestic projects as well as in international projects. So I'll leave you with just that thought that perhaps perhaps encompassing a social license to operate within more formal structures would be desirable. I think about the Bear Creek Mining decision and the majority versus the dissent, and ask whether it really should be an either or. In other words, it seemed to me that only the investor has the ability to do some things to maintain a social license, to achieve and or maintain a social license to operate, yet it is perhaps incumbent on the state to explain more formally what that is and what that means, so the investor can follow those guidelines and achieve the social license to operate. So I'll stop there. Thank you.
Thank you, Andrea. I think that there's lots of questions that are in my mind. I would like to leave you with one particular question, which comes to my mind. I mean, I have been now I believe that I consider myself a long proponent for reform of BIT's investment treaties by including by making them somehow more balanced, by including and clarifying that not only the state should have obligations, but also that investors should have obligations, and except for the basic notions of respecting good faith, which is a general principle of law and materializes through the obligation not to admit investments through corruption or admit investments through fraudulent acts. There's really no clear obligations in most of the treaties for investors. So the ones that come to mind is the obligation to respect human rights, or at least certain minimum international human rights by the investor, and also comply with corporate social responsibility standards. But the one thought that now comes to my mind is whether that's not sufficient. I mean, whether there's a handful of treaties that include some of those obligations, including treaties of some treaties of Nigeria and some treaties of other states. But the question is whether it would be useful to think about binding obligations by the investor to carry on consultations when the project requires it. That's more of a question, and that's something to be explored explicitly, including that in investment treaties. I haven't seen it, but out of this conversation, that idea comes to mind. And I would like to leave you with that question. I have already left Professor Anaya with a question. I would like to give the floor to Rene to ask a question to Justice Angel Cabo, and Justice Angel Cabo to do the same with him. So if you will, and if not, I'm happy to ask your question, but please go ahead.
Sure. Fine. So thank you, Justice Angel. So perhaps if you could elaborate on, the implications of in terms of the court for the more wider idea of investment and the relation between domestic courts and international law. So the way in which they interact. I mean, I know that you can't assess specific things, but
I cannot say much, but definitely international law plays a role in the decisions of the court, especially the decisions of the Inter-American Court. And so they are always considered as a source of our decisions. So basically what you're saying is really relevant, and how that plays, it actually works both ways, because there has been a lot of works that basically document how the Inter-American Court also receives from domestic jurisprudence and makes decisions also influenced by domestic jurisdictions. And so it plays both ways. And it definitely plays a role in decisions of the court. And so I have to ask you a question. So my question was concerning that you were mentioning the case on Colombia and France, the bilateral international agreement, and you were very critical of at some point of that decision, especially regarding participation. So perhaps if you could just elaborate on that a little bit, and you mentioned it in your presentation. So that's my question to you.
I don't know, Jose Antonio, should I answer that question first, or should we go in the order? What do you want?
We don't know.
Yeah.
So feel free to answer that question right away. And this is kind of a super rapid kind of
Wrapping up.
fast dating type of questions and answer, because we're running out of time. We have like 9 minutes at the most.
Wonderful.
Not for you. You have 2 minutes.
Yeah. So I was critical. I wasn't critical of the fact that the court engaged on a substantive review, but I was, of course, and I am, of course, critical, and I've written about this, and that the court didn't address the issue of participation and democracy as part of reviewing BITs. So the court focused on the more substantive investment issues as it should have, but my position is that it should have gone further to consider the right of participation and the democratic principle when reviewing the treaty. It didn't, and that's the part that I'm critical of.
Thank you, Rene. Professor Anaya?
Yeah, thanks for the question you gave me earlier. Well, consultations are of course required. In that sense, the duty of consultation is binding on states. They have to do it. And I guess the question that really arises is the outcome of the consultations. If there's not a consent or if communities oppose a project, well, you know, you have, as I mentioned, as Renee mentioned, the jurisprudence of the Inter-American Court in that regard. And I've tried to give a rationale behind it. You know, if there is a substantial material effect on rights of indigenous peoples, like their lands, if you know their lands are going to be used or affected, you know, the cultural resources, well, yeah, there has to be an agreement, just like with any other right holder. You know, it's not a matter of necessarily of being indigenous, except as to the rights concerned. I mean, if another person owns property and an investor is going to go into that property, there has to be an agreement. And so that same concept, you know, applies with indigenous peoples, except indigenous peoples have, you know, different kinds of rights to their lands and resources that have a cultural and spiritual connection. I want to make another point, and that is, you know, I agree with Andrea that this idea of social license is quite amorphous. And as I said earlier, it's not well sourced. And I don't know if it's the right route for investment, for arbitration panels to go if they're interested in human rights or rights of communities. I mean, we have much stronger tools. There are this concept of business responsibility to just respect rights. That's much more developed. It's much more concrete. And also it's, you know, there's this danger, and I'm seeing it manifested in our discussions here, of sort of conflating indigenous peoples, their right of consultation or the duty of states to consult, with this notion of social license. I mean, the social license, you know, it's not well sourced, it's amorphous, there are all these questions, but the duty to consult, there are very specific requirements that are in international law and that are also grounded in the constitutional law of almost all countries in Latin America and are part of the constitutional bloque or frameworks of increasing numbers of countries in Latin America, Colombia, Mexico, and others, of course. And so, you know, I think we don't want to, I appreciate what Professor Sands was doing and using this concept of social license to then talk about ILO 169 and the rights of indigenous peoples. But I find it somewhat, you know, a misguided approach to talk about the duty of consultation that states have with regard, if we're going to talk about indigenous peoples, let's put social license aside. Let's talk about this duty to consult. And there are very specific guidelines, you know, including with regard to representation. You know, it's indigenous peoples through their own representative institutions that consultations have to occur. It's not some amorphous for referendum or going house to house and trying to figure out what people want to do or walk around, you know, the town or have public meetings where anybody can show up. No, it's through indigenous people's representative institutions. Now, like Andrea pointed out, sometimes there are questions about what those institutions are, and those need to be worked out, just like there can be with a country. Sometimes, right, countries, you know, you don't, there's who's, there are questions about, you know, who the legitimate, you know, we can't isolate indigenous peoples and say, oh, indigenous peoples have those problems, so, you know, we have difficulty consulting. No, indigenous peoples are human beings like everybody else. And those things have to be worked out, but it has to be, but in principle, the principle is through their representative institutions. So anyway, I'm not a big fan of social license, as you can tell. I mean, I think it's a generally a nice concept, but it's got a lot to be worked out, as Andrea pointed out, and I don't want to see indigenous people's rights get mucked up in that discussion. The focus, when indigenous peoples are concerned, they have specific rights that are affirmed in international law and domestic laws, and there's a specific duty of consultation that's affirmed in international law.
Thank you, Jim, and then thank you for being so precise and descriptive with words in terms of describing social license to operate as an amorphous concept, which basically encapsulates. I understand where you're coming from. Andrea, last but not least.
Okay. So I'll just say, I think I agree with Jem. I would come at it even from a slightly different angle, or just add a few more observations, which is that, and I'll try to answer your question too, Jose Antonio, but with respect to investor obligations, I don't know that it hurts to have investor obligations to consult in a treaty or other obligations, but I don't think that should undermine the state's obligations. So one of my concerns when you start talking about imposing obligations on investors, and we see this in Bear Creek a little bit, is, and my question in Bear Creek is, where was Peru? Right? If the company is firing on protesters, I mean, of course that's horrible. That's terrible. That is a violation of human rights. The company should be sanctioned. But where's Peru? Why is Peru not protecting people? Like that's like, we should not excuse Peru even as we impose obligations or penalize the investor. That's my. So I think of that too, with respect to having obligations on investors to consult. Sure, that might be a good thing, but that doesn't excuse the state from its international human rights obligations to consult. And so I think that is something to guard against. And just on that note, with respect to imposing obligations in treaties, at first, I think the obligations need to be obligations the investor can do. So my concern in the Morocco, Nigeria bid and in the SADC model is that there's this obligation on the investor to do an environmental impact assessment, but there's no mechanism to do that. So is the investor going to, I mean, yes, the investor has an obligation of good faith, but one question is, who is doing the environmental impact assessment? There is no international agency that does environmental impact assessments. Normally it's the domestic, right? It's the domestic, environmental department. So that's just a little bit of a kind of an issue. And my concern also is that it's too late. Like in René's presentation, in his timeline, one of the things that I understand he was talking about arbitration more, but one of the things I found missing was challenging a state's decision to offer a concession contract in the absence of having engaged in the proper consultations, right? In the absence, and that strikes me as that's when you want something to happen. By the time you're in investment arbitration, it's too late. So I feel like that's a little bit the case with imposing obligations in treaties, when those obligations are not really going to come up until there's an investment arbitration, which means something has happened, something has gone wrong, probably there's damage. And really, I think we want to avoid that and not say at the back end, oh, it turns out you can't bring your investment arbitration case because you didn't do the consultations. I mean, okay, but still we want to avoid that damage, not kind of penalize the investor, not just penalize the investor after the fact for not having abided by their obligations.
Thank you, Andrea. And I realize that we're just 1 minute. I mean, we're done. We did extend the panel for over 15-14 minutes. I believe that this was an incredibly substantive, substantial, on-point panel. And as promised at the beginning, this panel would walk you through constitutional, inter-American, human rights law, going to international law, as well as investor arbitration. The topic is evolving. The presentation will be posted at the WOW webpage soon enough. We are also happy to announce that we have a term engine that will be good for searching different terms, which will soon be up and running. With that, I would like to thank everyone. I know that some of our panelists, Professor Jorklund, may have to leave right away. So please do so, Andrea. And we're really, really honored to have had you, Professor Anaya, Professor Luena, Ana Milena and Justice Angel Cabo. So thank you. There's one question. So from now on, we're good. We're good. Thank you very much. I have one last question. I don't want to leave one question off the table, and this is a question for Justice Angel Cabo. It's a very sort of theoretical question, which there's someone from the audience that had asked what would be a pro-arbitration judiciary?
No, I prefer not to answer that question. I have somebody in
Okay.
mind, but I will not answer.
Okay, good. Very good. Well, that's that is the answer for now, and everyone is very much welcome and invited to our next panel, which will be, Ana Milena will help me to tell me when the next panel will be.
It is in around 1 hour at 11:30 a.m. Eastern Standard Time.
Yes, and that panel will be on the Caribbean and institutional and arbitration development in the Caribbean. Today, as you know, is the Day of the Americas. So we're going from South America to the Caribbean and ending up in North America. So thank you all. Have a beautiful day, and I hope that we can keep discussing this, because I feel that we have as everything is only touched the tip of the iceberg. Bye bye.